But your Lordship has specifically directed that this matter regarding for challenging of the virus of the elementary teachers cadre rule, Lordship. No further adjournment will be given.
Today we are not granting any adjournment. Make your submissions.
Yes, Lordship.
Good. Sorry.
So what is your problem? You have given, so you are due also.
But I have to file in it. There is the sorry. Document.
File now.
I have made it.
Yes.
Not the way. Make your submission. Well. Before I make my submission, Lord, may I just be permitted to refresh the memory. Here the case is, Lord, 1987 cadre rule was governing the field for class 1 to 7. RCFC Act came into force in the year 2009. But after RCFC Act came into force in 2010, RCFC rule was framed by the central government and also RCFC rule was framed by the state government. Accordingly, in terms of section 23, 23(1), 23(1).
Rules, you are talking of the section or act?
Section 23 of the RCFC Act,
Okay.
from the BEAR Act. But qualification for appointment and terms of conditions of service. But any appointment, any person possessing such minimum qualification as laid down by the academic authority, authorized by the central government by notification, shall be eligible for appointment as a teacher. 2, where the state does not have the adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient number, the central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years, as the case may be specified in that notification. But the first proviso is important. Provided that a teacher who, at the commencement of this act does not possess minimum qualification as laid down under the subsection 1 shall acquire such minimum qualification within a period of 5 years. But with this proviso, and in terms of section 23(1), NCT was notified as prescribed authority, and NCT by notification dated 23rd August 2010 prescribed the qualification. That in my, although that is available in my REIT application and all the REIT applications also, and I have also endorsed in this spiral binding all of the documents they are relying, also we are relying for convenience sake, so that this can be utilized. The Lordship will find at page 49. But if your Lordship, are you commanding me? No, my lord. Please make your submissions. My lord. 49, my lord. Because my senior was taking the time.
No, we are hearing you. You continue.
But at least what I learned from the bar. There was objection from your side that no adjournment was required to be granted. No, make your submissions, please. Because the young lawyer, at least I obeyed from the. Please make your submissions. Please continue.
Mr. Sahu, you argued it earlier. So what is your problem? You are continue.
Yes,
continue.
my lord. Your Lordship, please page 49 of the spiral binding method. Page 49. For the minimum qualification as was notified by NCT was made two categories. One for class 1 to 5 in terms of the schedule appended to the RCFC Act, and another is class 6 to 8. Whereas class 1 to 5 prescribed secondary school's academic qualification and DLED or etc. that is the training qualification, and the teacher eligibility test pass is the qualification. That is also for the class 8 to 10, 6 to 8. The qualification is BA, BSc or the training qualification BA. Thereafter also added and teacher eligibility test. This is the qualification. This qualification was also little bit modified by virtue of the subsequent notification by the NCT. That is 29th July 2011. That not to the extent of the minimum qualification which was prescribed along with the TET pass. Then what happened? While this provision was governing the field, minor will find from the RCFC rule in consonance with the spirit of the proviso to section 23(2), which says that teacher at the time of commencement of the act shall have to acquire the qualification prescribed by NCT. But the RCFC rule, the central government framed it on 9/4/2010. In the RCFC rule, in upholding that spirit, my lord will find 19. The 17, 18 are there. The 17 is also minimum qualification. 18 is relaxation of minimum qualification. Only the central government to relax on the proposal of the state government and examine the proposal and thereafter by notification will relax. There is no such provision under the act for exemption. Only relaxation is there. But then 19 is relevant. Why I am drawing the attention to the 19? Because there stand something different. We are prior to RCFC Act appointee. Therefore, the DT is not for us. I will bring to that because that is the contention I have replied in my reply. 19, Your Lordship, kind ambulance. The heading is acquiring minimum qualifications. Rule, my lord. The state government and union territory shall provide adequate teachers' education facilities to ensure that all teachers in the school referred to in subclause I and school owned and managed by the central government or state government or union territory or local authority under subclause 3 of clause N of section 2 who don't possess minimum qualifications laid down under subrule 2 of rule 17 at the time of commencement of the act to acquire such minimum qualification within a period of that was 5 years and it has been reflected here is 9 years after 2017 amendment came into force into the act. Because by virtue of 2017 Amendment Act, but the proviso, the earlier stipulation of 5 years to acquire qualification was extended to by adding 4 years. That is 9 years. That has been carried in this bare act manner. Then it makes it clear, teacher who don't possess the minimum qualification laid down under subrule 2 of the rule 17. That means 17 is consonant with that, the section 23. Who don't possess minimum qualification laid down under subrule 2 of the rule 17 at the time of commencement of that to acquire the qualification. But this is the parameter provision is also available in the Orissa RCFC rule. is available in book, my lord, the education manual. May I just read in light of my lord, 17, my lord. Acquiring minimum qualification. Government shall provide adequate teacher education facilities to ensure that all teachers in school referred to in subclause I and schools owned and managed by the central government or the state government or local authority under subclause 3 of clause N of section 2 who don't possess minimum qualification laid down under subrule 2 of the rule 15 at the time of commencement of the act to acquire such minimum qualification within a period of 5 years from the commencement of the act. That has been also enhanced because of the central government, the parliament doing an amendment in the year 2017 by extending that 5 years limitation, which was ended by 31st March 2015, that was extended to 31st March 2019. And accordingly, my lord will find that I have also quoted, I have also in this bunch of the spiral, the binding, I have given the amendment. Parallelly, before commencement of that RCFC Act and the rules, NCT had the NCT Act, which was governing the field, prescribing the standard of education and also the qualification. 2001 regulation was framed, and what happened after commencement of this RCFC Act? NCT Act was amended in the year 2011. My lord will find that NCT Act that I have made available, that is at page 70, my lord, of the spiral binding. I have given all the documents, even they usually rely, we also rely. All the documents I have attempted to bring to your lordship's notice, since it will govern at least lakhs of teachers' fate, my lord, in the Odisha. But at page 70, this is National Council for Teachers Education Amendment Act 2011. But by virtue of this amendment, your lordship will find just 71 page. May I draw your lordship's kind attention 6. After section 12 of the Principal Act, the following section shall be inserted, namely, that is 12A, for the purpose of maintaining standards of education in schools. The council may by regulation determine the qualifications for persons for being recruited as teachers in any pre-primary, upper primary, secondary, senior secondary or intermediate school or college by whatever name called, established, run or aided or recognized by central government, state government or local authority, other authority, provided that nothing in this section shall, although they have not relied, but I want to bring to your lordship's kindly, shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, secondary, senior secondary, intermediate schools or colleges under any rules, regulations or order made by the central government, a state government or a local authority or other authority immediately before the commencement of the NCT Amendment Act 2011 solely on the ground of non-fulfillment of such qualification as may be specified by the council. But the proviso is important. Page 72. Provided further that the minimum qualifications of a teacher referred to in the first proviso shall be acquired within the period of specified in this act or under the Right of Children to Free and Compulsory Education Act 2009, my lord. That he referred the proviso of the RCFC Act, my lord. My lord, this amendment was necessitated after commencement of the RCFC Act so far the elementary education is concerned. My humble submission before Lordship is, which I on the first occasion, since they had not made any submissions, confined to section 23 proviso, first proviso and second proviso, and also confined to the relevant the RCFC rules and the central RCFC rule and the state RCFC rule. Here, I rely on how the proviso of stipulation covers the teachers at the time of commencement of the act. That RCFC rule says they have to acquire. Who don't possess the qualification, teacher on the date of at the time of commencement of the act, who don't possess the qualification, they have to acquire. Odisha rule also framed that says in the same manner. And even the NCT Act which was amended, but that says by proviso they have to acquire the qualification. But they may continue notwithstanding the qualification. But the statutory obligation is they have to comply the qualification as prescribed by the NCT notification dated 23rd August 2023. The second fold of submissions which I had submitted, by relying upon the A.B. Krishnan judgment and also Patna High Court judgment, but the impugned order, I have not just refreshed the memory. Impugned provision is 97 cadre rule was amended in 3 phases that I have given in the compilation. In 2009 it was amended, 2014 it was amended, and 2019 it was amended. But by virtue of that amendment, 11, Rule 6 and 11 and Rule 15 was substituted. And in 15(2)(d) proviso, it was provided that teachers appointed prior to 11 February 2011, they are exempted from the TET qualification. That provision is under challenge. And even the Rule 6 of the elementary cadre rules, your Lordship will find that also I have enclosed in this spiral binding. That is at page 95, page 95. Although I have quoted in my the compilation of the rules and regulations. At page 101, from the bottom portion, the second paragraph, provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teachers Eligibility Test 2. But that is under the challenge. My humble submission was that in RCFC Act, neither the RCFC Act nor the RCFC rules, central or state, nowhere provide empowering the state government to bring exemption. Only RCFC Act rules both says regarding the relaxation. Relaxation, that is subsection 2 of section 23, that says central government will only have the power to relax upon receipt of proposal from the state government. Therefore, bringing a exemption provision by the state government in exercise of power under Article 309 proviso is it suffers from legislative incompetence. That was my first round of assailing the order. And second is but that since the rules, the Act, Central Act and rules, even the Odisha rules, read with 23rd August 2010 qualification as prescribed by the NCT is governing the field. Is prescribing TET that is occupied by the legislation which has been duly recognized by the state rules, also central rules, and that cannot be overridden by any power exercised under 309 proviso. That is hit by the principles of, as your lordship also initial occasion that the Patna High Court judgment pointed out. Patna High Court judgment basing upon that principles of occupied field, Krishna A.V. Krishnan Malar, was the Bihar rule 4 of the which given an expansion providing competency test. No, you cannot court said, Patna High Court, you cannot provide a competency test in place of DT when the central act already governing the field providing a DT is the essential qualification. Then the state government has cannot prescribe a different examination competency test. Therefore, that was passed. That I had authority I had placed But in gist, these are the grievances. Then the further submission, my lord, which I had developed, that the petitioners from the beginning, my lord, they are with academic qualification, training qualification, and DT pass, my lord. Even the yesterday batch which had come, but that the teachers also the possessing the DT qualifications. What happened by virtue of this impugned exemption provision? All the non-OTT, that means the underqualified persons, they are getting promotions from one level to another level. Before going to that, let me kindly turn to the elementary cadre rule which was governing the field. That is page 1. Page 2 may kindly have a glance on that. Page 2 of my spiral binding. Page 2, that the constitution of service of the elementary cadre service, which is being followed, it was the 5 levels, but now it has been by virtue of the 2019 amendment 6 levels. Your lordship will find service shall comprise of the following levels, namely the Odisha Elementary Education Service level V and Odisha Elementary Education Service level IV. Odisha Elementary Education Service level 3, Odisha Elementary Education Service level 2, and Odisha Elementary Education Service level 1. Your lordship will find the eligibility for direct recruitment. I will come to their point, but I categorically replied in my reply affidavit. Eligibility is, but they have to fulfill all the conditions. But the page 4 is, he must have HSC pass and have completed so and so. And your lordship will find they have to be selected. All the initial level of 5 is to be filled up by direct recruitment, and the level IV to 1 is to be filled up by our promotion. This is being followed. But your lordship will find that I am just drawing your lordship's kind attention to the 2014 amendment of the elementary cadre rule 73, page 73. But I want to draw your lordship's kind attention to page 80, last portions. That explanation 1A was added to in 2014. All persons now working as primary school teacher under Jilla Parishad, kindly mark, having requisite training qualification, that is CT or B.Ed, shall be treated as member of the level 5. But prior to insertion of this provision, all the teachers, they were not the level 5 cadre teacher. They were Swachhasevi Shiksha Sahib, that's a volunteer under the Sarva Shiksha Abhijan scheme. And after completion of that, the circular, that the entire development as I have given, after completion of 9 years, in total 5 years completion junior teacher, thereafter 4 years to be the teacher under the Jilla Parishad cadre, because it was transferred to the Jilla Parishad. Then what happened, that 5 years and 4 years was further subsequent resolutions that are also enclosed, that was amended to 3 years and 3 years. Within after completion of 6 years, one will be teacher, but under the Jilla Parishad. They were not the teacher of level 5 till 2014 amendment by virtue of this clause. And by the time they were come over to this level 5 cadre, they had no also the OTT pass qualifications. And that is the grievance of the one of the grievance, that we are appointed as teacher. It is not correct. I have shown your lordship, your lordship will find page 9. For volunteers, 4.1. And those who accept the terms and conditions offered to render voluntary service would be engaged as such. And following that, my lord, your lordship will find described the qualification of senior secondary, my lord. My lord will find by that time HSC Odisha rule, my lord, elementary cadre rule prescribed HSC, whereas he prescribed the senior secondary the qualifications. But then subsequently, your lordship will find in 2006 the engagement of Shiksha Sahayak, Swachhasevi Shiksha Sahayak, their designation was changed to the Shiksha Sahayak, and engagement of Shiksha Sahayak will be made by the Jilla Parishad as per requirement under the program of elementary education and Sarva Shiksha Abhijan. They were all recruited as volunteers, and even as a Swachhasevi Shiksha Sahayak or Shiksha Sahayak under the Sarva Shiksha Abhijan scheme, and their placement was made under the Jilla Parishad, not under the level 5. And for the first time in 2014, they come over to the level 5 cadre.
That you told. Yes.
And that, at this juncture, I want to come to my reply affidavit. May I read the reply affidavit?
No, not the entire affidavit, only the portion you want to read.
I have made it on specific answer. I beg apology for my younger juniors, your lordship. I beg apology for my younger juniors.
No problem. After that, he will address, so don't worry. Yes.
That reply affidavit para 1. In reply to the first continuation regarding clause 4 and 5, may I draw the attention to the clause 4 and 5? Thereafter, what was their submission? Their defend, my lord, and what is my lord? Clause 4, 5 of that 23rd August 2010, my lord, that is the NCT notification prescribing qualification. That is, here is available at page 49. And that is my answer. May I want to just refresh the memory what was their submissions for teacher appointed before the date of notification. The following categories of teachers appointed for classes 1 to 8 prior to date of this notification need not acquire the minimum qualification specified in para 1 above. Para 1 is that qualification of DT with the training and academic qualification. And in one regulation says the secondary and they were continuing which says teachers appointed prior That is why they have been given the exemption provision under the Elementary Cadre Amendment Rule 2019 is will not will not be given effect to, will not stand as a bar. The teacher don't possess qualification at the time of commencement of the act shall have to acquire the qualification. Even NCT Act section, the date of commencement of the act, at the time of commencement of the act, they have to acquire the qualification. Therefore, 4, 5, I have answered because in Devesh Sharma's judgment, my lord, I have already professional qualification level, my lord. They took the view until that is not in dispute. From 23rd August 2000, status, my lord, court stipulated under the second proviso to section 23(2) of the Right of Children to Free and Compulsory Education Act 2009 applies to such person only who did not have the minimum qualification as laid down by the academic authority authorized by the central government by notification under section 23(1) thereof. They have relied on Gazette notification dated 23/8/2010 issued by the NCTE paragraph 4A, of which contemplates that certain category of teachers appointed under class 1 to 8 prior to the date of notification need not acquire minimum qualifications specified in paragraph 1 of the said notification, and thereafter, Your Lordship, relied upon the bill, Your Lordship, that in the on para 4, Your Lordship, that the interveners have submitted that for just interpretation of second proviso of section 23(2) of the Act, this court may take aid of highlights of the Amendment Bill 2017, which is part of the legislative note, and that they may be permitted to file affidavit along with the documents relied on by them. Lordship, in portions that Your Lordship, this order, they have filed an affidavit regarding that such notification is only applicable for those required for appointment and not for the promotion, Lordship. Lordship, so far as section 23 is concerned, Your Lordship, may you permit. Section 23 speaks about qualification for appointment and terms and condition of service of teachers. Section 23(2), Your Lordship, where state does not have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. Your Lordship, in this the appointment, Lordship, there is a specific judgment of Honorable Supreme Court that the appointment also includes promotion, Your Lordship. May I please, Your Lordship. Your Lordship, that is 2006 to SCC 482, Your Lordship.
Or in the time of promotion. That is the only the point to be decided here, my lord. Only I beg to draw lordship's attention to the 97 rule. That is the 97 rule, your lordship. That is the at rules 3. That is the elementary education service level, which starts from level B and ends with the level 1. The promotional facilities, that is the 11, at rule 11, the eligibility for the promotion, it has been specifically stated, in order to eligible for the promotion of this belonging level 4 of the service candidate must have served for continuing
those have continuing in level 4, 5B, they have to pass level TET 1 or TET 1 to be promotion to level 4, provided that such teachers, senior teachers in the level 5B of the service exercising their option to become graduate teacher have passed Odisha eligibility test That means from level 5B to any other level, if a teacher will be promoted, to any next higher level. This is the provision as prescribed by the state government in Rule 15D2, my lord. There is no such exemption for any teacher. But in D1, the state government provided exemption of a TET from level BA to level BB, my lord. Here is the crux. When teachers without TET are promoted to the level 5B, and without TET they are continuing in level 5B, then how they will be promoted to next higher level, either level 4 or level 3 or any other level? There is no exemption in D2, my lord. Therefore, since D1 is contravention to the RT Act and subsection 2 of the section 23 of the RT Act, therefore the petition challenge this. This is the ultra virus to be declared the ultra virus. Therefore, my lord, I am coming to page 37 and my lord, and this is my submission before this.
Heavily damaged and disturbed, and that will give rise to, that is why the ballot. That way I have given my note.
Yes. Was appointed prior to 23rd August 2010, and after enactment of the RT Act 2009, which came into force on 1/4/2010,